Hi there, I'm Jim Zirin. Welcome back to more Conversations in the Digital Age. Our show is about the Supreme Court of the United States, shorthanded since the death of Antonin Scalia in February 2016. For almost 150 years, the court has consisted of 9 justices. It wasn't always that way. Congress organized the court in 1789 with an even number of 6 justices. The complement grew to 7, then 10, and then back to 9 as an economy measure in 1869. When President Obama nominated Merrick Garland, a seasoned jurist of impeccable qualifications, to succeed Scalia, Senate Republican leader Mitch McConnell blocked the nomination, saying that the next justice should be elected by the American people, which is exactly what the Constitution does not say. Then Republican Senators McCain and Cruz said they would do their best to block anyone nominated by Hillary Clinton, so the court could stand at 8 justices for years to come. My new book, Supremely Partisan, How Raw Politics Tips the Scales in the United States Supreme Court, argues that we have sadly moved towards a politicized judiciary. And today we thought we'd try something new, turning the tables. Here to talk to me about my book and the state of the court is the distinguished diplomat, historian, lawyer, and philanthropist, Bill vanden Heuvel. Bill, it's over to you.
Jim, I'm so glad to be here today. I can't imagine a more timely book than in this year to have this book written. It's called Supremely Partisan, and I recommend it to all of you, lawyers and non-lawyers alike. It's perhaps the most important commentary on the third branch of our government, namely the Supreme Court established by the Constitution with its own constitutional areas. Now, Jim is the perfect author of this book. He himself is a significant litigator and lawyer in our community. He has written a prior book called The Mother Court, which was about the Southern District Court, which has had a very considerable audience. The foreword to this book, by the way, is written by Kermit Roosevelt, the great-grandson of Theodore Roosevelt, who himself had a number of contests with the Supreme Court, especially when he was the candidate. Now, you mentioned, Jim, that Senator Cruz and Senator McCain have indicated that they will not support any Hillary candidates if she wins the election. Actually, McCain went further. I read his speech in Pennsylvania. He said that he would personally block any nomination to the Supreme Court if Hillary Clinton were made president. How do you react to that? And if that's the case, and presumably he has that power since its individual senator can block confirmations, what does the country do?
Well, I think it's going to be very difficult because Senator McCain's position is hardly a profile in courage for a senator. The Senate can, of course, refuse to advise and consent to the nominee of a president. If under senatorial rules, one senator can block a confirmation vote, those rules will have to be changed. And it'll really, the responsibility should fall on the American people and the public to pressure their senators to change the rules so that one person cannot engage in obstructionist politics.
It's going to be difficult to rally the country because although the Supreme Court is an iconic institution, it's not one that Americans understand very well. It seems to me that the turning point in all of this was Gore against Bush in the year 2000, where the Supreme Court intervened in the state election and declared Bush to be president of the United States. Do you think that decision was correct?
Well, certainly, I don't think it was correct, but that was a 5-4 decision, and the 5 justices who were appointed by Republicans voted for Bush, and the 4 who were appointed by Democrats voted for Gore. As it happened, it was probably all academic because the New York Times counted the vote in Florida after the election and after the inauguration and determined that Bush would have won the state anyway, although it was a very close election.
That's interesting. Sandra Day O'Connor, who was a Republican appointee and the first woman, I think, on the Supreme Court, was quoted after she left the court, and she's had a considerable public career since leaving the court, that she made a mistake in that vote. That was struck me as...
Yes, she regretted her vote. What was interesting, though, was during the time that the case was pending, she went to a cocktail party in Washington, and others were present, including members of the press, and she said it would just be terrible if Gore won the election. So it was clear where her sentiments lay, at least at the time, although she regretted her vote later.
It's great, the Supreme Court, with all these points of criticism and concern and vulnerability, at the same time represents an opportunity for Americans to find the compromises that enable us to live as a society. And it seems to me that one of those situations has been race in America. I mean, for 200 years we had the most brutal of all human institutions, slavery. Then we had the context of, we had a civil war where 600,000 of our children were killed out of a country of 30 million at that time. And then in the century after that, we saw the concerted efforts of a part of the country to destroy the meaning and effectiveness of the constitutional amendments that were adopted. Could you comment on how we got to Brown against Board of Education, which ultimately ended segregation, at least constitutionally ended segregation in America?
Well, it was a long, hard road, Bill, as you've outlined. The founding fathers, and particularly the authors of the Constitution, principally Hamilton and Madison, white Anglo-Saxon Protestant males, also slave owners themselves, as was George Washington, although later he released his slaves.
And Jefferson.
And Jefferson certainly,
yeah.
Although he wasn't so involved in the Constitution as in the Declaration of Independence, but they understood that if they tried to attack the issue of slavery at that time, they never would have gotten a government. They never would have gotten a Constitution. So they decided to kick the can down the road. And we then, the Supreme Court became involved at the time of the Dred Scott decision, a horrible decision, one of the darkest days, if not the darkest day in the history of the court, which, in an opinion authored by the first Catholic on the court, Roger Taney, who himself was a slave owner. And Taney held that slaves were not citizens of the United States, and they didn't lose their status as slaves when they went with their owners to a free state. And he declared the Missouri Compromise unconstitutional, which said the opposite, and that led to the Civil War. Civil War was fought, and in 1868 we had the 14th Amendment, which guaranteed the equal protection of the laws. Now, I think if the framers of that amendment ever thought that it applied to school desegregation, it never would have been enacted. Mm-hmm. It would have said equal protection of the laws except with respect to school segregation. But they didn't think about it, so they framed language which had a majestic ambiguity to it. And you had the case in the late 19th century, Plessy against Ferguson, which held that separate facilities, if they were equal, were constitutional.
I was going to mention the Plessy case because it's in the repeal of that case that you finally see the light in the question of race in America. But that's the question of taking old cases and turning back is very much on the table now when you have Citizens United too, right?
Yes. Well,
can a court go in and do that and repeal a case?
Well, of course, the Plessy case was overruled 56 years or so after
specifically
it was handed down, specifically overruled. And in stirring words, Chief Justice Warren said, separate facilities in schools are inherently unequal and therefore violated the 14th Amendment.
Right.
Now, it is legitimate for the court to overrule decisions when the decisions no longer comport, at least I believe in this interpretation, comport with contemporary standards in society and with the fabric of morality that's ingrained in the American people and fairness. The difference now is that you see them overruling decisions within a year or two after they're made, and often because of a change in the personnel on the court. So it raises the question where if changing judges changes the law, what is law anyway?
Well, a comparable situation where that happened was with Roosevelt and his proposals for court reform in 1937.
Yeah, popularly known as court packing. You like to call it court reform.
I call it court reform.
Because you're a Rooseveltian.
He was suggesting, all federal courts retired at the age of 70. They could stay on the bench and they could have a working function, but their places could be filled. So he was suggesting that this should be the case with the Supreme Court as well. Now, what he was facing was an absolute group of 4 or 5 judges who were adamant against the economic philosophy of the New Deal and the role of the New Deal in saving the country from the Great Depression. So the question really was, can a group of 9 who are responsible to no one, who are accountable to no one, and who are appointed for life with no constituency other than the President and the Senate confirming it, can they overturn the will of vast majorities of Americans as the New Deal had? For example, Roosevelt only then began to confront the court directly when it was clear that they were going to rule on constitutional Social Security and minimum wage. And you just mentioned that now overturning cases happens in a matter of years, a couple of years. So it happened then. In order to save his court, the Chief Justice, Charles Hughes, reversed himself in 2 different cases and made it possible. But that Lincoln faced the same thing. Any great president faces the same thing. You're living with a court that's appointed by your predecessors who may often be very opposed and in conflict with the philosophy of your government. How do you think that history should handle it?
Well, this is the check and balance that the Constitution created. Because you go back to 1789, while it does in Article 3, the Great Charter sets up a Supreme Court, it does not say that the court has the power to declare acts of Congress unconstitutional or acts of the executive unconstitutional. It wasn't until 1803, the year before Hamilton was killed in a duel, it wasn't until 1803 that John Marshall, the 4th Chief Justice, seized the power of judicial review. And it's been accepted ever since.
Right.
So he said that the court is for the judicial department to declare what the law is. And we've accepted that. That's part of our rule of law.
Right.
So for better or for worse, yes, you're right, a Supreme Court appointed by predecessor administrations and predecessor senates can declare unconstitutional acts of the president or acts of Congress. Now, what happened with the court reform bill was that Roosevelt, who felt that you had a lot of old men on the Supreme Court who didn't understand, in those days you had no women, and he said they didn't really understand the pressing economic crisis that we were in at the time, and they were using the Due Process Clause in effect to legislate. And so he said, let's expand the number of judges to a maximum of 15, and he could appoint an additional one for everyone who was over the age of 70. Well, that bill was dead on arrival in the Senate anyway, but while it was pending, one justice, Owen Roberts, who had always been a conservative, went the other way. That was called the switch in time that saved 9. And and he upheld, the court upheld a New Deal measure on the minimum wage.
And one of the judges retired.
And well, one of the judges retired. So by the time Roosevelt was through, he'd appointed 9 justices to the United States Supreme Court. He didn't have to worry about it anymore.
I think Wendell Willkie said, those who think that Roosevelt lost this battle are wrong. He won the war. And we got Social Security, and we got minimum wage standards and all of those things, which were on the verge of being declared unconstitutional. I mean, think of the power of one person in these 5-4 decisions that we've now witnessed, the Citizens United case and the other case. The power of one person to say what this country is and what it should be. You raised the question, the personnel of the court. You change one judge, you can change the law. There's a lot of interesting instances of judges who've been appointed who've had great influence, and one of them is Earl Warren. And the fact that Earl Warren, or the reality that Earl Warren brought in one of the most controversial issues in Brown against Board of Education and got a unanimous court to speak for it. I've always thought spoke wonders for what he did. People say that Eisenhower, who appointed him, would regret it later, that appointment. Herbert Brownell denied that. He thought 2 of the great liberal judges, right, Warren and Brennan, were appointed by a very conservative president.
And it has been popularly thought that Eisenhower said that those were the 2 worst mistakes he made in office. But what is really extraordinary is you look at Earl Warren. Earl Warren was a prosecutor in California because he was a Republican politician. He was a skilled politician in getting people of diverse viewpoints together and to agree on some consensus. And he was really one of the principal architects of the Japanese internment during World War II.
And he was a great civil libertarian.
And they wound up a great civil libertarian. Now, he was joined by none other than Hugo Black, a Roosevelt appointee. Now, Hugo Black was a Dixiecrat senator from Alabama. He was a member of the Ku Klux Klan. He was anti-Catholic. He actually prosecuted a priest and then railed against him afterwards in churches throughout Alabama. Later, he said he just did it to get votes. Who would have thought he would be one of the most liberal justices on the court? And one of Roosevelt's greatest appointees in the view of
And he was
many
probably
scholars.
appointed because Roosevelt understood that because Black was a sitting senator, that he would be confirmed by the Senate with a few questions asked.
And also Roosevelt in 1937 was fresh from a victory in 1936, which he owed to the Democratic South and the Dixiecrats. So this was undoubtedly a political payment for all the support he'd gotten in the South. And now, Roosevelt was a great politician as well, you know.
When you look at a person who is appointed to the court, it seems to me that there are many instances, certainly, and there should be a demand that the president appoints someone not precluded by his political antecedents, but assured by his or her character and by the capacity of that person to rise above the political partisanship that had been part of their important careers. In other words, how else would you have a court of greatness unless you had men and women who were available for appointment, who, when they were appointed, rose above their prior careers and understood that they were serving the nation and were serving the Constitution, and that their political parties were not a point of reference?
Well, we've seen many instances of that. Interestingly enough, most of them justices appointed by Republican presidents and who became moderates or liberals once on the court. So we had Potter Stewart, we had Lewis Powell, we had David Souter, and it is nothing. And we even had Sandra Day O'Connor. Nothing short of amazing how they took centrist to liberal views once they were on the court, even though they were appointed by conservative presidents. Of late, starting with Scalia and going on into the presidency of George W. Bush, but also George H.W. Bush, who appointed Clarence Thomas, can be blamed as well. We have conservative justices appointed by conservative presidents who adhered to their conservative views once on the court in a very doctrinaire and partisan way. And that is what's nothing short of amazing.
One instance where the public's attitude really affected the appointment of the court that I can think of is Herbert Hoover. When Oliver Wendell Holmes retired at the age of 90, there was a clamor in the country among those who were representative of the law for Benjamin Cardozo to be appointed, who had no real party, had been elected as a Democrat to the Supreme Court of New York State. But Hoover did appoint him. And
yes, Hoover did appoint him, and that is an interesting story as well, because at that time we had seats on the court. There was a Catholic seat, and there was also a Jewish seat. Now, the first Jew to be appointed to the court after bitter confirmation hearings that lasted 4 months was Louis Brandeis. He was sitting on the court at the time that Holmes retired. He and Holmes used to vote together all the time. Interestingly enough, Brandeis was appointed by Wilson, a Democrat, and Holmes was appointed by Theodore Roosevelt, a Republican. And yet here's a Republican and a Democrat voting together all the time on issues of free speech and the other landmark dissents that they wrote together, and which in many cases became the law later. But at the time that Hoover was considering Cardozo, there was a hue and cry that now there'd be two Jews on the court. And Hoover had the assurance that Brandeis was going to retire shortly thereafter, and Cardozo was such a star, judicial star, he was appointed to the court and was seated.
Which Brandeis did not do, by the way, right?
That's right.
Brandeis stayed on.
He stayed on for a while,
but you know, the court is populated by an extraordinary diversity of Americans. On that same court was Justice McReynolds, who had been an attorney general, I think, under Wilson, and he was so anti-Semitic that he would never shake hands with Brandeis. And often, when Brandeis was speaking in the conference, etc., he would get up and leave the room. When you think of people of that nature sitting on the court and making decisions that affect all of our lives, one wonders whether we have done enough vetting in terms of those who have been appointed to the court. But you mentioned the seats. You also, the book, let me say the book again, this wonderful book, Supremely Partisan. It's really a wonderful read.
Oh, Bill, you're too kind.
But you mentioned in there that there have been 112 justices appointed since the beginning of our country. That the first 89, with the exception of Tawney, I guess, were all white Protestant Americans. And now we have a much more diversified court. Could you comment on that, on the introduction of women to the court?
Well,
meaning of Roe against Wade?
In a multicultural society, appointing authorities, political leaders tend to think of selecting one from Group A and one from Group B, particularly in the modern era. And you can remember our own mayoralty contests in New York, where it was Lefkowitz, Gilhooly, and Fino against Beam, Procaccino, and O'Connor. So we had a Catholic seat for a while. Interestingly enough, Catholics did not always vote in accordance with the views of the church. Brennan, who was a devout Catholic, joined the majority in Roe v. Wade.
And Justice Murphy was one of the most liberal.
One of the most liberal, Justice Murphy. Of course, he was a bomb thrower. His grandfather was hanged in Ireland as a rebel. But Murphy dissented in the Korematsu case.
Yeah.
But there were Jackson, a white Anglo-Saxon Protestant, dissented as well.
Yes.
And what brought them together? What brought them together was our wonderful Constitution, right, and their conception of it as being something that guaranteed individual liberty, which it does. And now we have a much more ethnically, I can't say diversified, we have a minority court because it's 100% minority. And when Scalia was around, it consisted...
I mean, that's interesting to say. With Scalia sitting in the court, we had 6 Catholics and 3 Jews.
That's right.
After 2 centuries of domination by white Protestant...
And if Garland is seated, we will have 5 Catholics and 4 Jews, and no white Anglo-Saxon Protestant males. These wonderful people gave us Brown v. Board of Education and gave us Roe v. Wade and other very liberal decisions. So, yes, we
concentrated east of the Mississippi too. These judges.
Yes, well,
only Kennedy, I think, is
Kennedy's from the West Coast.
That's the only one.
Yeah, Roberts, born in upstate New York, grew up in Indiana, but spent his professional life in Washington.
Yeah.
And the rest all were East Coast. And they went to Harvard or Yale Law School, all of them.
Yeah.
Except Ginsburg left Harvard to go to Columbia because her husband moved to New York. But she's a product of Harvard as well. Harvard certainly claims her. And we have 3 women on the court. We have a wise Latina woman. We have an African-American justice who replaced the iconic Thurgood Marshall, although he votes against black interests, it appears, every time the issue is presented.
Right.
So we have an ethnically diverse court.
The nation has faced the diversity question and has realized that since the court, to be accepted as the Supreme Court, must be accepted by the people of the United States. And by this diversity in its membership, it's done that. We're coming to the end, but one of the judges that I think both you and I have admired was Robert Jackson.
Yes.
And Jackson, I think you quote him saying in the book, we are not final because we are infallible. We are infallible because we are final. And it's because it's the end of the road for telling what the law of America is. The court has that enormous power. Jim, this book is a great service to the nation, not only in an election year, but to the history of the court, which is so crucial to American democracy.
Bill, I can't thank you enough.